Alrighty, I want to talk to defense attorney Louis Gainor right now. He's a criminal defense attorney, and we want to really focus in on this whole residual doubt thing. So thank you so much, Mr. Gainor, first of all, for being with us.
Thank you for having me.
Okay, can you explain to us a little bit, for folks who may be just joining us, what exactly is residual doubt as opposed to reasonable doubt, and how does it play into this trial?
Well, every death penalty case proceeds in a bifurcated fashion. That means the first part of the trial is as to guilt or innocence of the defendant. The second part of the trial is as to the appropriate punishment, either life imprisonment or the death penalty. So in the second phase of the trial, the standard is there any doubt whatsoever that the defendant committed the crime that would prevent you from imposing the death penalty? So in the first part of the trial, to determine someone's guilt or innocence, the question is there reasonable doubt? Once they say there is no reasonable doubt, they go to sentencing. And there, it's like the second opportunity for the defense to try the case. They can say, well, you already determined that he was guilty, but are you really sure you want to do that? And it may be difficult for people to grasp, so let me give you a concrete example. In order to find somebody guilty, the jury has to vote 12-0, has to be unanimous. So then it goes to the sentencing phase, and during the sentencing phase, all 12 may have said, we believe beyond a reasonable doubt that he did it. But there still may be one or two jurors sitting there saying, you know what, I believe that he did it and I will agree with everyone, but I still have slightly a doubt that will prevent me from imposing the death penalty. So residual doubt is reasonable doubt. And the idea is that it gives one or two jurors who decided to agree with the verdict an out and a way to say we're not going to impose the death penalty.
Well, what about in a case like this where it's a bench trial? There is no jury, there's just the judge.
Well, that's interesting because here the courts would say that we presume that the judge knows what the law is and that the judge would try the case just as a jury would. Whether that actually happens, well, that's up for debate. But the judge is supposed to apply the law. Now, in this case in South Carolina, the jury is not entitled to receive an instruction during the sentencing phase about residual doubt. So the judge is not required to think about that. In fact, the only thing the judge is required to think about is mitigating factors, reasons why that punishment should not be imposed. And so what's the biggest mitigation in this case is the fact that the two bodies have never been found. That is really like residual doubt. You could believe beyond a reasonable doubt that the person committed the crime. But without the bodies being found, you may have 1% or 2% doubt that he did it. Not enough to say that you're going to acquit him, but enough for you to say, well, I think I might spare him the death penalty. Okay,
I gotcha. How does, and it is such a unique case, and we were talking about this yesterday, that judges need to be death penalty qualified. How do you become death penalty qualified as a judge?
Well, judges and lawyers both have to go through a screening process through the state Supreme Court. The state Supreme Court will set out certain criteria that they have to meet, such as a number of jury trials and a number of murder trials. Once they do that, they get certified. It's a process that's meant to ensure fairness for the defendant and also to protect the prosecution. Because if the attorney representing the defendant or the judge presiding over the case is not qualified, that would give the defendant an avenue of appeal. And so it would also, it protects the prosecutor in the respect that they only have.
Alrighty, hey, Louis Gainor, I thank you so much for bringing us your insights on that. I mean, that was a segment where we really learned a lot, and we appreciate it. Take good care.
Thank you for having me.
Thank you. All right, let's bring in criminal defense attorney Louis Gainor back into the conversation here, because I wanted to ask you, Louis, about sentencing and how it differs between a bench trial and a jury trial. I mean, we weren't real sure how much leeway attorneys have to present a case before a judge for the sentencing phase, as opposed to a jury. Is there any difference?
Well, the law says there should be no difference, but the practice is completely different. I would say there's basically two types of lawyers. There's lawyers who present themselves in court for the benefit of their clients and prospective new clients, as in they're putting on a show. And then there's lawyers who present themselves in a way trying to get results. So with the judge presiding over sentencing, generally speaking, it's all about credibility. You can't go on and put on a show for people in the courtroom hoping that they might hire you for their cases. You have to present yourself in a way that would convince this judge to give you a good decision. That can be extremely difficult because there's so much pressure on the judge at that point. Because during sentencing, who's sitting in the courtroom? is the family of the victim. Sometimes it can number into 100 people. And then there's the family of the defendant sitting on the other side. Can you imagine the position that that judge is in, having to weigh those two sides? So it's important that it's all about credibility. You have to, and that, in this case in South Carolina, I heard his opening statement. I liked what he did because he made it personal. He talked about what influenced him as a child, the story about his father, the police officer, when he was 11-year-old in Vengeance. That's a good way to go because he's putting himself all out there and saying, this is what I've got, Judge, this is who I am. I think that's typically the way to go. It's not a good idea to put on a show to make a name for yourself as a lawyer.
Would it be a smart idea, in your opinion, to have, well, the convicted murderer now, Kenneth Lynch himself, speak to the judge?
That is a tough question. You know, most people don't know this, but being a criminal defense lawyer is really an easy job, except in a few circumstances, and that's one of them. When you tell a client whether it's a good idea for him to take the stand, because there you're making a decision and you have so much more experience than that person, and if you're wrong, it's going to really hurt him. Typically, you don't want your client to talk at sentencing, because what's he going to say? Are you sorry? I mean, that doesn't mean anything to most judges, doesn't mean anything to anyone. At that point, the best thing you could hope for if your client gets up there is that he or she breaks down and that took place. But most often, your client is in denial and doesn't want to do that. So it could be a total disaster to have them testify. So I would usually counsel them, don't say anything, let me do it for you. That's why they sent me to school, and have them sit down.
You know, Louis, there was something that happened that we all caught on to. Because this is a bench trial, we were surprised that the court clerk would still go ahead and announce the verdict. Why wouldn't the judge just do that himself?
Well, it's typically a rule of procedure. The court clerk always announces the verdict rather than the trier of fact. For a jury, they elect a who will hand the verdict to the court clerk to do. So it's usually just written in the rules of procedure. In some respects, they do that because they want to protect the authenticity of the verdict, the reliability of the verdict. The idea is that they want the verdict to be taken from the trier of fact and then handed to the court, because it's the court's purpose to officially announce that decision. It's not the trier of fact. They just make the determination as to what it is. So that's usually typical.
Okay. Hey, thank you so much, Louis Gainor, for taking the time to be with us today. Great, insightful information. We appreciate it. Have a good holiday.
You too.
Thank you.